Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. We've got a great lineup of guests tonight that on a topic and a subject matter that is incredibly timely. You're going to want to stick around for that as well. A couple of ground rules just to kind of let you know in case this is your first time with us. You'll see at the bottom of your screen ways that you can converse with us. We'd love to hear from you. That information will be at the bottom of the screen all throughout the show. And just a reminder, Hollis Wright makes available attorneys who are standing by live during the show to take your calls. That's a free, confidential, all fair conversation. So it could be on the subject matter we're talking about or something else. If you need some free legal advice, that opportunity right there, Hollis Wright makes that available to you. From the firm of Hollis Wright, he's a managing partner, Josh Wright. Good to see you again, sir.
Good to see you too. Happy holidays, Merry Christmas to you.
You as well.
Everything going well?
It's all good. You?
Going your way?
It seems to be going my way. Thank you.
Well, good. Let me tell you this. In the era of Me Too, which we all see on the news consistently, this show topic is right on point with that whole concept. And we're going to be talking about sexual harassment tonight. A little statistic that's important that I got from our guest, and that is that roughly 2,500 EEOC claims for sexual harassment are filed per year in 2017 at least. So this is very prevalent in Alabama. It's a real prevalent topic that I think we're going to be able to kind of walk folks through understanding sexual harassment, retaliation, those types of things.
You know what's interesting about this certainly for personal behavior, this show is going to be helpful, but you know, we're both business owners, and the way and kind of the culture and the climate of the workplace now, well, if you own a business, this is a show you're going to want to take notes on.
100%. And John Saxon, who has a practice here in town that specializes in this area, is going to be with us today as an expert. This is one of those topics where we're not experts in this area, so what we do is we bring folks on. So first of all, John, welcome aboard.
Thanks, Josh.
And I know you'll help us kind of lead, guide, and direct us through this process. How did you get into this area of the law? I often start this question to a lot of our hosts or a lot of our guests, but it's really relevant here. This is truly a specialty in the law. Not every lawyer handles this. How did you get into this? Because you got to be good at what you're doing in this area of the law. How did you get into it?
There are very few of us, not just in Birmingham, but in Alabama, who do plaintiff's employment work, representing individuals mistreated in the workplace. And I got into it in the early 90s when you have one case and it kind of leads to another. I had one or two that were kind of high visibility cases. And over time, it just became a specialty. And I don't do anything but employment work.
Well, and I know it keeps you busy because we get a lot of calls, texts, and emails each week on the issue of sexual harassment or workplace harassment of some sort or some employment-related issue. All right, let's kind of kick off our topic of sexual harassment tonight. How do you define sexual harassment? How is that defined in the law?
It is unwelcome conduct based on sex or gender that is either has to be endured as a condition of employment, to be continued to be employed, or it is severe or pervasive to the extent that it creates an environment that is intimidating, that is hostile, that is abusive.
So in this Me Too era that we're in now, have you seen an uptick in the number of cases out there of those that are bold enough to come forward? And just kind of, let's talk about that for a second.
I don't think I've seen an increase in the number of victims who have come forward. What's interesting is, and I don't know whether employers have gone too far in the other direction, but I have seen people come to me who have been terminated by their employer for things that they have done or have been accused of doing that in the past probably would not have resulted in their termination. And I've not been able to help them because we're an at-will employment state, meaning you serve at the will of, at the pleasure of your employer. And I think employers, particularly large ones, and this is probably a good thing in general, they're trying to improve their culture and trying to have a zero tolerance policy for this conduct or misconduct. And you can argue they may be going too far. by terminating people for things that in the past they might not be terminated for.
This goes back to the concept, you know, about being a business owner and making sure that the climate and the culture at your location is run in an environment where you have people that are happy to be there, that aren't subject to this type of thing. So I can see why folks have overreacted just a bit.
Because I wonder, I mean, it's kind of like the stock market, you know, whenever there's a really big dip, a few days later there's a big correction, right? It goes over the other way. Do you think that may be happening here, that there have been things that have been allowed that when you think about it, you shouldn't be doing those anyway, right? And is there possibly an overcorrection that will result in us getting where we need to be?
We'll have to just see what plays out over time. But when you look at the things that fueled the Me Too movement about a year and a half ago, with Harvey Weinstein, you know, Matt Lauer, Charlie Rose, Roger Ailes, Senator Al Franken, Congressman John Conyers, Kevin Spacey, and a host of others.
You could go on.
People in the media, people in the entertainment industry, people in the political world. When you read and heard about those abuses, you realize, gosh, man, this has been going on a long time with some of these guys. Yeah. And you throw in Bill Cosby, and you throw in a little bit of the Brett Kavanaugh confirmation hearings, where we're seeing people not just years, but decades later coming forward. And people said, well, wait a minute, why did their employers tolerate this for so long? And so there has been a legitimate and good effort to try to remedy that. And sometimes when there is a correction, it can go too far. I don't know that that's happened, but I've had at least 2 people come to see me. I don't think they would have been terminated in the past.
How do you explain the delay a lot of times? Because I get this question a lot as a lawyer. Well, you know, that person delayed a decade, 2 decades to come forward, but there's a rationale and a reason for that a lot of times, isn't there?
There is, and it's mainly because they fear retaliation. And you say, well, what kind of retaliation? Well, the death penalty of retaliation is termination. They lose their job. But it can be other things. In the fast food industry, and there's a lot of sexual harassment in the fast food industry, you got men and women working together in tight quarters, you know, behind that counter, getting those burgers out. And somebody complains, they get their hours cut. You get your hours cut, you're not making as much money. You get them cut below some levels, you're not getting benefits. They can be cut out of important meetings, taken off of important emails, frozen out, or have denied promotions, all kind of things. So it's not just being terminated, but they fear that. And in the workplace, if you know Mary complained a year ago and she got fired, or some other coworker complained and their hours were cut, you're not going to do it. And a lot of times the sexual harassers, they're very clever. They pick out people who might be a single mom with kids and a deadbeat ex-husband, and they know she has to have that job. Sometimes, if they have the freedom, like a physician I had once represented 5 women in his office, he paid them more. He knew they could go elsewhere, but they wouldn't get paid as much. And they had to have those jobs.
So there are laws, though, that protect against retaliation, are there not?
There are. All of the employment laws. So we're not just sexual harassment, but race, gender, national origin, taking family and medical leave act leave, age, disability, all of those statutes include anti-retaliation provisions. So if you're retaliated against, it gives you a second separate cause of action.
What do you recommend if someone feels like they are being discriminated against or sexually harassed? Do you recommend that they come to a lawyer early? I mean, do they go to HR first? How do you manage that?
There's some wisdom in talking to an attorney early, but in order to engage in what the law calls protected activity. That's complaining either to a supervisor, if the supervisor is the harasser, complaining to their supervisor, going to HR, or even going to the EEOC, the Equal Employment Opportunity Commission. But I always advise clients that there is the risk of retaliation, and there are ways you can do it that maybe help to create a paper trail to prove and document that you're being harassed. That maybe won't get you terminated.
When we come back, one of the things I want to talk about is whether or not, in order to be successful in a sexual harassment case, you have to prove economic loss. Is that a requirement? to be successful in a case. We're going to talk about that, and I know John will be able to knock that out of the park for us.
Good deal. We'll pick up right there. Let's step aside real quick. Reminder of how you can get in touch with us. Also, don't forget those attorneys standing by, and check out Hollis Wright on social media, Facebook, Instagram, as well as Twitter. Just search Hollis Wright. You'll find him there. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys. Really fascinating conversation we're having tonight. We're going to get right back to it, but a reminder, those attorneys from Hollis Wright standing by live. All you have to do is pick up the phone and give them a call. That free, confidential, off-air conversation is yours for the taking. Josh?
All right, so when we went to break, we talked a little bit about, and I kind of teased this for this segment, on the issue of economic damage. If you have been sexually harassed and you file a suit, do you have to prove economic loss? Do you have to prove, for example, that you were terminated from your job in order to be successful, or are there other ways to get damages?
You do not have to prove economic loss. You simply have to prove that either it was a condition of your employment to put up with this harassment, or that the environment itself was hostile, abusive, intimidating because of the conduct. And sometimes there is economic loss. If you complain and you're retaliated against and you lose your job, or you have your hours cut, or some other things I've already mentioned, often there's economic loss, but it's not a requirement. And for the employee who is still there, and I have handled cases for employees who stayed at that job while the case was going on. Now, it's difficult for them. It's tough. Yeah. But often there's not economic loss.
And a lot of times those people will keep their job because there's you're not able to retaliate against them, right?
Well, it gets tricky. Yeah. But yeah, an employer who wants to do the right thing will protect them and see to it that nothing happens. Sometimes they get rid of the harasser, sometimes they don't.
How do the contracts with lawyers work in the sexual harassment context? In what we do, a lot of times we're dealing with a contingency fee arrangement where we're not going to charge someone unless we're successful in a case, and only if we're successful do we get paid. In your area, it's even more pro-plaintiff, is it not?
Well, I think most of the lawyers who do what I do it on a contingent fee basis. But these federal statutes, not the case if you're in state court for assault, battery, invasion of privacy, false imprisonment, but the federal statutes have what are called fee shifting provisions, meaning the fee shifts from to the prevailing plaintiff. And now you have to go all the way. You have to try a case, have a jury verdict in favor of the plaintiff. Then you submit a fee petition, meaning you have to keep records all the way through the litigation from the start. And then you submit your fee petition, and the court awards fees that come from the losing employer. But the way most people do it is those fees go into the pot that then gets split up according to the contingent fee agreement.
But it does help in some ways, as the employer ultimately will pay some of those if you're successful, and the court awards fees.
That's correct. And in fact, this is not sexual harassment, but I recently saw a result where some local attorneys in a overtime case, the Fair Labor Standards Act case, got about a $5,000 jury verdict. Their fees, which went on and on and on forever in this case, and it could have been settled, their fees were about $200,000, and the court awarded them.
And it's because obviously they worked those hours, and even though, as long as they were successful and got a result. So what are some examples, like case examples, that you see most consistently?
Well, you don't have to have physical contact, but quite often there's physical contact. Grabbing, groping, slapping on the rear end, all manner of things. There's a lot of times there's language, talking in a way to somebody or showing them things, pictures in the internet world, pornography. I'll tell you the worst example, and it gets to the Me Too movement and why someone would stay silent. I had a woman come to see me some years ago who was the executive assistant to a very senior business executive here in town. And she would come into work, not every day, but where you sit in a chair and there's your desk and here is your workspace right in front of you. She would find little clear plastic sandwich bags with her boss's feces in it. And she came to me, and that wasn't the only thing that happened. And I mean, that's just a sick puppy, somebody who does that. And, but I always tell people, I say, number one, if you file a lawsuit, that's a public document.
Yeah.
And press may pick it up, they may not, but they need to be warned, that's a public document.
Yeah.
Second, I talk about retaliation, and she wanted to think about it. She called me back a few days later, she said, Mr. Saxon, I just can't do it. I have to have this job, I'm paid very well. I know what will happen. He will fire me, and he will see to it that I don't work anywhere else in this town, and she didn't go forward. Now, that was some years ago. My guess is if that person, if all of a sudden somebody else came forward, and just as we've seen happen, she might come forward later, all these years later. Yeah. But people fear retaliation. It is a very real fear. And it happens. I've had many, many clients who went to HR or complained to somebody or filed an EEOC charge and then they got terminated.
So that's just someone that's trying to show power of some sort.
Well, sexual harassment is about power. Yeah. And in that example, it's, I have you so much under my thumb that I literally can make you deal with my feces.
Wow. Awful. Question we've got here, can someone bring legal action for same-sex sexual harassment?
Absolutely. The Supreme Court has ruled that same-sex sexual harassment is actionable. So, the typical sexual harassment we see is a male supervisor and a female subordinate. But it can be the reverse, it can be a female harassing a male, and then it can be same-sex, male on male, female on female.
Now, one of the reasons, and we're getting ready to go to break, that you go to a lawyer relates to whether you have administrative requirements before you ever go file your lawsuit. I want to talk about that when we come back, because there are some requirements through an entity known as the EEOC where you've got to put them on notice. I want to talk about that and let John kind of hit that for the viewing audience so they know they can't just go file a lawsuit. They've got to actually dot some I's and cross some T's first.
Sounds good. We're picking up there when we come back. Time is just flying, so if you want to get a question in, you see that information, take advantage of that opportunity. The final segment of The Attorneys coming right up.
I'm attorney Carter Clay with Hollis, Wright Law Firm. If you've ever been involved in a civil lawsuit or been a witness to an accident, then you may have been asked to give deposition testimony. In this week's Legal 411, we are answering the question, what is a deposition and why am I being asked to give one? Depositions involve the process of a person giving under oath testimony that is outside of court. The person giving deposition testimony is referred to as the deponent. Depositions are taken in the presence of a court reporter, and the court reporter records the testimony. After the deposition, the attorneys for the parties received a typed transcript that contains all the questions that were asked by the attorneys, as well as the answers given by the deponent. The purpose of taking depositions is to ensure that the attorneys for the parties have a full and complete understanding of the events giving rise to the lawsuit, as well as an understanding of the testimony that they can expect to hear from witnesses at trial. Another reason an attorney might want to get deposition testimony is that it allows the attorneys to better prepare for trial and to develop a strategy for presenting the case to a judge or a jury. At trial, the deposition testimony can be used in several ways. First, if a witness on the stand deviates from the deposition testimony, an attorney can use the deposition to impeach the witness. Also, if a witness forgets certain facts or events, the deposition can be used to refresh the witness's recollection. Finally, in some instances when a witness simply cannot attend trial, the trial judge has the authority to allow the deposition testimony to be read to the jury. If you are a party to a lawsuit and are requested to give deposition testimony, your attorney will likely spend a significant amount of time preparing you for the deposition process to put you at ease and make you feel comfortable. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back in to The Attorneys. Just about 7 or so minutes remaining. If you want to take advantage of this opportunity to speak with attorneys live from Hollis Wright, you got about 7 minutes to do so. So go ahead and jump on that phone and give them a call.
John, talk for a minute about the EEOC and how that process works, because it really is kind of the start of a lot of these harassment cases,
Sure.
isn't it?
Yeah, when Congress passed the 1964 Civil Rights Act, it grew out of the civil rights movement, was largely directed at giving rights to African Americans. But Congress also said, well, let's include some other things, and gender was one of them, along with national origin, religion, so forth. They created the Equal Employment Opportunity Commission, thinking in the beginning that actually it would take care of a lot of these cases and they wouldn't wind up in federal court. That hasn't really been the case. But it is an administrative prerequisite for sexual harassment, a sexual harassment claim in federal court. You have to go to the EEOC first. The tricky part there is you have 180 days, close to 6 months, but not quite 6 months, 180 days from the date something happens. So if somebody's grabbed and groped, they have to get to the EEOC and file a charge of discrimination within 180 days, or they're time barred. Now, they may have a cause of action. If there's some touching, you may have battery. If their escape from a room is blocked, they might have a false imprisonment claim. If they're intrusive questions, they might have an invasion of privacy claim. And you can file those in state court. Don't have to go to the EEOC. Longer statute of limitations.
Yeah, and John makes a great point there, and that is that, you know, generally there's a tight statute of limitations. We talk a lot in personal injury cases, wrongful death, 2 years, sometimes with contractual claims, 6 years. With EEOC-related claims or claims that are in federal court, it's generally 6 months. But what John just raised is super important. It's why you get to a lawyer early. Even if you've missed filing an EEOC claim within 6 months of the last date of some form of discrimination or harassment, you may still have other claims that are available that extend your statute of limitation to state law claims. And so he raises a super important point. It's why you get to a lawyer quickly.
Yeah. You know, I'm curious, you're talking a lot, John, really about folks that you represent who are being harassed. Are you ever asked for advice from business owners, like in the age of Me Too, you know, kind of some ground rules and just a general understanding of how to run your business in
I've done
2018?
it a couple of times, and in fact, a couple of young guys about 2 years ago came to me, and one of their fathers had owned a plumbing company, and they were going to take over the company and run it. And they came to me, I don't know how they got my name, and they said, we want you to just tell us what employment law is. We want you to tell us all of the things that we should do right to avoid litigation, being sued. We want to make money. We don't want to spend it on lawyers. And so they paid me by the hour and spent several hours with me, just literally from A to Z. Here's what employment law is, and here's what you need to do. And I've had a few other friends who were at companies who might call me up and I've helped out, but mainly I'm representing the employees mistreated in the workplace.
Now, those are two proactive guys.
Yeah.
I suspect that business did okay.
I bet.
I bet
I was really impressed with them. They said, we want to get it right.
Yeah, that's impressive. All right, so with kind of the Me Too movement and the way that has evolved over the last 18 months, do you see an increase in the number of these cases being filed nationally, a decrease? I know we talked a little bit about maybe employers reacting, and even in some circumstances maybe overreacting, but are you seeing an increase or decrease in the number of cases filed, or is it pretty consistent?
No, and if you look at the EEOC statistics, and I think you put some of them up on the screen, is not any appreciable increase in these being filed. What I think is going to happen with the Me Too movement, I think two things are significant. One, the law evolves a lot, and I think as more and more people, young lawyers, law professors, people who are going to wind up being federal judges one day, as they see why so many women, particularly women, don't come forward who've been harassed, it goes to the issue of what an employer defense is. An employer can escape liability completely if it's not a manager who's the harasser, but a coworker, and the employee doesn't complain. You can't fix what you don't know is broken. Right. And so there are affirmative defenses that employers can avail themselves of, but they require that the employee unreasonably did not complain. And so I think over time we'll be able to show it's reasonable to not complain, because Susie complained and she got fired. The second thing that'll happen, I think it'll help in jury selection. You know, this pool, the venari, the pool of prospective jurors, we get to question them most of the time. Right. Some judges limit it, but you can get a discussion going and get people talking about how it is that folks don't come forward, because a lot of times they don't, and that becomes an issue in the case.
That's why you get someone like John involved. Wow.
Yeah. We've got about a minute and a half remaining in the show. Really interesting conversation, John, but want to just give you a chance for a final thought from you for our visit.
Well, the point Josh made about statute of limitations, a lot of people think, oh, you got 2 years to get to the courthouse, or a year to get to the courthouse. You got 180 days to get to the EEOC if you ever want to have a sexual harassment case in federal court. And so you don't have to have a lawyer to do that. I think it helps. And a lot of times we have people come to us who've already gone to the EEOC, and we have to do an amended charge because there are things they did not include.
I would just say, you know, there's a process that folks use when they're in this type of environment. Nobody deserves to work within this environment. Nobody. And everyone's accountable, from the CEO all the way down. Getting a lawyer involved early, or at least the HR department early, to assess what your rights are super important. Guys like John can really help you out.
Great job, John.
Great job.
Thanks so much. Thank you for being with us. Thank you for being with us as well. We always appreciate the time. As we wrap things up, here's how you can get in touch with the firm of Hollis Wright. Look forward to hearing from you, and we'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.